So a huge thank you, first of all, to Adam Brink, who is an advocate with the High Court, and then attorneys Jan Tromp and Johan van Schalkwyk. Gents, I very much appreciate your time this morning. We are going to be discussing something that's important in the EXP world. EXP is a real estate company that grows unbelievably fast. It's the fastest growing real estate company in history and now in South Africa's history. After 18 months, we've got about 450 agents and growing at an unbelievable rate. But the growth of EXP and the massive influx of agents from other companies into EXP means that we very, very commonly run into this problem where an agent who wants to join EXP has a restraint of trade in the contract that they've signed with their current company. And so rather than be irresponsible in how we deal with agents when we're speaking to them about coming across to EXP, I am wanting us to put together a little resource which we can use for three groups of people that I've outlined now, with the idea of being responsible. You know, that is my big concern here, is that I don't want any of our agents advising others unwisely, because everybody wants to be an amateur attorney and just tell people, oh, a restraint will never stand up in court, just come, just ignore it. But that is irresponsible. These are people's lives we're talking about, and I've had circumstances where agents have joined us and have now had their hands tied for 3, 6, even 12 months and longer, in fact, in some of the cases we've dealt with. And so I'm wanting us to get the facts, and that's what the three of you are going to help us do today. So thank you. By way of introduction, this is the last thing I will say before I hand over to you, Jan, is I'm wanting this to be a resource for three groups of people. First of all, agents who are thinking of leaving their current company and joining another real estate company, in our case, EXP. What should they understand about the restraint of trade that they may have signed in their contract? So that's the first audience. Then existing EXP agents, members of my own team, who are having conversations with agents in order to bring them across to EXP. How should they be advising other agents when there could be a restraint? And then the last group, which may be surprising, but this really is a group of people I would like also to benefit from this resource, is principals or team leaders of other real estate companies whose agents have come to them and said, I would like to leave. I'd like agency owners who have a restraint of trade with one of their agents to maybe rethink the position, maybe rethink the terms of their restraint, both from a legal perspective and perhaps from an ethical perspective. I just think this is a very big issue in the real estate industry, which does need discussion. And if we can all come to a common understanding and agreement, I think it'll be helpful. So that's it from me. Thank you, gents, for joining me. Very much appreciate all of your time. Jan, let me hand it over to you in order to give us just some kind of legal introduction to the matter. I think most people watching this do understand what a restraint of trade is, but maybe you could give us a brief introduction to the matter, and then you can hand over to our other two experts for their comments.
Thanks, Stephen, and good morning, everyone. Thanks for the invitation to be here. I'm going to just make a few comments about restraints, and then I will hand over to Advocate Brink, who's going to make a feature presentation about restraints, and also we have Johan van Schalkwyk, also is going to add to the matter. So this is a very big issue at the moment, especially where there's disruption in the market. For example, with property practitioners, there's movement always. And, sometimes when times are tough, it can be extremely difficult if you're restrained from trading. It's going to affect your livelihood. So imagine now a document says you cannot work in a certain area for 6 or 12 months. And that's your trade. That's what you do. That can be devastating. So many people automatically think, oh, that can't be right. Therefore, I can't be bound. But actually, on closer inspection, it's more complicated than that. Because in South Africa, we have, in Latin, it's pacta servanda sunt. It's there's the sanctity of contract. When you sign on the dotted line, we all know as South Africans, when you sign on the dotted line, you're bound. We generally know that. Excuse me. And that is key, and that's what it is. And what we have found is where people have signed a restraint of trade, and I'm not going to describe it, it essentially, as I say, it's where you cannot trade in your area for a certain period, you cannot act as an estate agent. If you sign on the dotted line, courts have largely said yes, you cannot trade. The courts have upheld them, but there's been a balanced approach, and I'm not going to go into it now. But the main thing to know is that if you do sign that thing, there's risk. There's risk, and the courts might not help you. So there is another competing principle in South African law, and that is under the Constitution, freedom of trade. Everybody needs to earn a livelihood and to make a livelihood. So in times of COVID, for example, courts have been wanting to assist people and say, well, here, because the economy is so bad, we're going to maybe look past the restraint of trade and allow you. But there's various decisions on the matter. I think the key thing to know, we must be cautious. For example, the Consumer Protection Act has put out a sort of a feeling for people, I can get out of this if I give notice on 20 days or 5 days. But let's remember, this is an employment contract. The Consumer Protection Act does not apply. And the golden rule, I'm going to say the common sense thing is, agents, if you sign something, read and understand what you sign. Read it and understand it. It sounds silly, but how often do we just sign something, especially if the print is fine? So ask a fellow property practitioner that you trust, what do you think of this? It's not legal advice, but it can be good advice. And if it's going to affect you severely, which it can, then go to an attorney. Okay, so that's signing it. Then, of course, we get to the point of once you are bound, of course, and then it's going to be a question of there is a restraint of trade. How do you get out of it? I'm going to leave that to Advocate Brink. But essentially, before you make the big drastic move, certainly get legal advice, because then it starts to get legal implications. Yeah, and then just one more thing, and that is that when you sign a contract with the estate agency, it's not only the restraint of trade, you need to look for the other little sharks lurking around there. For example, there's something called a retention clause, a 30% retention clause that some people sign, and it says when you leave, they can keep 30% of your commission as an admin fee. What is that? That's nonsense. I mean, it's not an admin fee. And a court has struck down one of those recently, but you need to be looking for those. So some of the more experienced agents, for example, of EXP, I've seen some of their contracts, and I've seen when they signed them, they had certain clauses deleted. So there's some smart people in the pack, and and when they went, they said, oh, I'll sign this, but I want to delete this, for example. Okay. All right, so I'm going to leave it at that, and I think the whole purpose of this session is to empower the property practitioners in South Africa who need to make moves. They want to move from place to place, and why not? You know, you sign up with someone, but you want to move elsewhere. It's normal. You have the freedom to do it. And I think this session is intended to empower and inform before you move. Just apply a bit of not just common sense, get the advice and take the step carefully, but there are things you can do. Okay, and just finally, sometimes the restraint needs to be put aside, but sometimes you can just make it a little better by negotiation. You could go to the agents and say, listen, okay, let's just cut it down to 3 months. I can't do 12 months, but I can do 3 or I can do 6. So there's different ways to skin a cat and different things you can do to improve your position. But with that, I really want to hand over and thank Advocate Adam Brink, who will lead us into the subject in detail. Thank you, Adam.
Yes, Jan, thank you very much for that introduction. You've stolen almost all of my thunder. Thank you for it. Let me begin at the very beginning. There are 2 ways in which you can be prevented from competing with your ex-employer. The first is that you can agree not to compete with your ex-employer, and that's a restraint of trade. But there are also all sorts of laws based on something that we call unlawful competition. So, for example, if you have been employed by your employer, you can't steal their secrets, you can't steal their client lists, you can't disparage them in the marketplace, and so on and so forth. Those are really ethical laws which have been brought into our law to prevent unlawful competition. Because, of course, our law very strongly is in favor of competition in the marketplace. We have massive sets of laws to prevent unlawful competition between companies, price fixing, gouging, and so forth. Companies get fined millions of rands for any step that prevents competition. But there has always been this exception with regard to restraints of trade. And restraints of trade are generally enforceable. So we used to have a belief in our court system that a restraint of trade was generally not enforceable unless the employer could show that it was necessary to enforce it. And then in 1984, the Appellate Division, which is now the Supreme Court of Appeal, which at the time was our apex court, said that a clause in restraint of trade in a contract is no different to any other clause in a contract. We enforce contracts in this country, except in very limited circumstances. So a court will not enforce a contract if it's contrary to public policy. But if you have signed a restraint of trade, you must accept. Sorry, I think I froze for a moment. If you have signed a restraint of trade, you must accept that you will have to do the running to show that it's contrary to public policy for it not to be enforced. So first things first. First, you've got to make sure whether or not there is a restraint of trade. And it happens quite often that the first time an employee really becomes alive to the fact that there's a restraint of trade in the contract is after they've left, because they never signed it. They were so grateful to get a job, as people are, that they would have signed pretty much anything that was put in front of them, and they did. People don't read contracts. The mere fact that you didn't read a contract doesn't mean that it doesn't bind you. That's a very firmly established principle. Caveat emptor. Let the buyer beware. Caveat subscriptor. Let the person who signs beware. These are established principles in our law. So I think the first piece of advice is read your contract before you sign it. There may be very nasty things lurking in there, and if there are, and you've signed it, you'll be bound by it. Secondly, I've often had people say to me, and Jan mentioned it, that we have a constitution now, and Section 22 of the Constitution reads as follows: every citizen has the right to choose their trade, occupation, or profession freely. Now, estate agents are professionals, and they therefore have a right to exercise their profession freely. But the Constitution also says that the rights in the Bill of Rights may be limited. That's at Section 36. So there's some rights that can't be limited. So the right to life can't be limited. But the right to choose your trade, occupation, or profession freely is one that can be limited. And one of the ways it can be limited is if you've agreed to limit it with restraint of trade. So that constitutional argument has been had. It's been raised before and it hasn't worked. So the notion that the Constitution makes all restraints of trade unenforceable isn't one that will work. It was raised in a matter called Advotech, which is judgment of Judge Davis in this division, who said that because there's the Constitution, everything must change. And it went up to the Appellate Division, and in a matter called Bread and Cup, the Appellate Division said nothing has changed. Still a public policy question. So the question is this: when will the court enforce these clauses, and when will the court not enforce these clauses? The courts have made it clear over the decades that they will look at every single one on a case-by-case basis. So there's no one-size-fits-all piece of advice you can give with regard to a restraint of trade. But there are a whole host of factors that are relevant. The courts take a balanced approach. What they try to do is they try to look at what commercial interest it is that the employer is trying to protect. So if there's no commercial interest that the employer is trying to protect, then the only thing it's trying to do is stifle competition. Or if the clause is disproportionate to the protection that they need, then the court will find that, in fact, it's a disguised attempt simply to stifle competition. And they look at a lot of factors. So the first and most obvious one is, what is the position of the employee? So if you are simply the receptionist or a messenger, and you sign a restraint of trade saying that you can never work at an estate agency within the environs of the city of Cape Town and the city of Johannesburg, then the court will look at that and say, what protectable interest is there? It's just a messenger. It's just a receptionist. We'll strike that down immediately. But if you are brought in at the top as the head of marketing for a large estate agency, the court will probably find that that sort of interest is protectable. So the first factor is, what role do you play in the employer? Makes a big difference. The second factor is, what did the employer give you in return for your being willing to be restrained? Were you given some sort of a sign-on bonus where they said, look, we'll pay you this amount, but in addition, we want you to be restrained and we're willing to pay you? So that's the first factor. That should be a point. That should be a point in favor of enforcing this restraint. And also at a basic level, what were you paid? So if you were paid very little, but are going to be restrained for a long time, that's disproportionate. That's not fair towards the employee. And I noticed in a couple of these contracts that I've been sent, the people are in fact paid nothing by way of a salary. It's purely on a commission basis. And whether or not that person earned commission during their tenure would be a factor. So if they were able to say, look, I sat behind the desk at that estate agency, but I was never given any leads, I never sold a house, I never got a cent, sat there effectively for free for 6 months, I think a court would find it unfair to restrain the person. The third issue is what you brought to the table. So if you brought with you an extensive knowledge of the industry which you had before you were with your employer, then your employer's argument that you have acquired that knowledge of the industry through them and that is their protectable industry will be greatly weakened. So, for example, someone who sells timber for a living moves from one timber company to another timber company, you can't really argue that he learned everything about the timber industry from the second employer. So the second employer's right to restrain him would be relatively weak. So too with estate agents. I know that these contracts talk about trade secrets, but there isn't really an 11 herbs and spices within the estate agency business. They all do pretty much the same sort of thing. The only thing that they have, which is crucial to protect, is the people on their book, buyers and sellers. Those things are certainly protectable, but this talk of trade secrets, I think, is a little overblown in the contracts I've read. And then we enter into another factor about whether to restrain someone. It's whether they had actual access to the thing that you're trying to protect. So if, for example, the person never had access to the clients, never had access to the client lists, never had access to the book, that should be a factor against restraining them. The next factor is a absolutely crucial one, and it's the one that has occupied the attention of the courts the most, and it's the duration and extent of the restraints of trade. So I saw one recently where a person who worked in Pretoria and who had never worked anywhere other than Pretoria and had no links to anywhere other than Pretoria, was restrained from working anywhere where the company had business interests. And the company had business interests across the Republic and right the way up to Zaire. That geographical extent is simply too large. Whereas one of the agreements that Jan sent me, which is for a franchise of one of the biggest ad agencies, says that you can't work within our franchise area. So that franchise area would be very small. In Cape Town terms, it would be Sea Point or Southern Suburbs or Atlantic Seaboard or such like, a very small area. A court would regard that as a reasonable restraint because you don't have to continue operating in Claremont in order to live in Cape Town and continue to be an estate agent. So it depends a great deal how large the area is. And then secondly, duration. The record for what has been enforced in our country is a restraint of trade that was said to be for 25 years. That was for a doctor in a small town who was selling his medical practice. And the evidence was that there was only scope for one medical practice that could survive in the small town. And that if the outgoing doctor were to come back at any point, he would prevent the person who bought his business from being able to operate. But that is a very extreme case. The rule of thumb depends entirely on the industry. So you have industries that are short cycle and you have industries that are long cycle. Estate agencies are relatively short cycle. So somebody will come to you wanting to sell a house, and all things being equal, the deal will be done within months and that'll be the end of it. Similarly, when you are dealing with somebody who wants to buy a house, and that's the other side of your book, because you'll have sellers and buyers in your book, and the magic of being an estate agent, the reason you get your commission is you manage to link buyers and sellers. Your buyers won't be on your books for very long either. So you'll have somebody wanting to move up in the world, down in the world, somewhere else in the world, and they'll be looking for a house now. It'll be something that you can help them within months. What that means is if your business cycle is that short, restraining somebody for 2 years is too long. So I would think that I've seen in these contracts 2 years. I would think that that sort of duration is far too long. I would imagine that, and it's just guesswork, I would imagine that a court would be reluctant to go much beyond 6 months. But what I am saying is that a court could probably be convinced to enforce something for 6 months. So that's the duration. A factor that the court doesn't take into account, and those of you who've read your restraint of trade agreements will see that they often include recordals or acknowledgements. So there will be an acknowledgement that just by working for them, you acquire knowledge of their trade secrets and are in a position to damage their business. Or there will be an acknowledgement that the extent and duration of the restraint is reasonable. Those sorts of things the courts ignore almost entirely. The reason for that is that when the court is trying to determine whether or not it's against public policy to enforce a restraint, there is only one opinion that matters, and that is the court's. The opinion of the parties expressed in the contract is irrelevant to that process. So those clauses won't be enforced. Another principle that's important to the courts is you can't stop a person using their training. So if you say in the contract that you will be trained by us, we will teach you your trade, we will put you in a position to be an estate agent, and therefore you can be restrained for a period. The courts don't like that at all. So the courts regard on-the-job training the thing that goes into and stays in your head, as something that you can't be restrained from using after you've left the employment of the estate agency or whatever the other employer is. So that if all that they're trying to do is to prevent you moving on with your training, where there's no other protectable interest, the courts won't permit that. Something that Johan touched on is, as another factor, is the state of the economy. So the courts are very alive to the fact that it's very difficult to get jobs. And they're very alive to the fact that losing a job is something that has far broader consequences. When you lose your job, you lose the ability to support your family, you lose your ability to maintain your right to housing, you can't pay the rent anymore. And you lose something which the Constitution regards as even more important. You lose your right to dignity. So we don't have a right to work in the Constitution, but we have a right to dignity. And a very important part of the right to dignity is the right to be economically active and self-supporting. So the courts take that very seriously. And there was a judgment which has not been followed since, but there was a judgment during COVID where the court said, at a time like this, nobody is going to be permitted to enforce a restraint of trade. The fact that somebody has left your employment and has managed to find other employment during this economy is something that simply shouldn't be interfered with. So the court does, to a limited extent, look at the economy, and not very often. The court also looks at how it came about that the restraint of trade was signed. So there's a pretty common practice in a number of industries, which is a pernicious practice, and it's a hiring and firing ruse. So if you have a competitor, and that competitor has, for example, a particularly good marketer, somebody who really brings in the business, the ruse is you lure that person across and you pay them for a restraint of trade, and then you fire them. So you've neutralized them by taking them away from your competitor, and all you've done is you've paid them a little bit of money for it. But your intention was never to employ them to promote your business. The intention was simply to steal them from the competitor and neutralize them by paying a little bit of money. If that can be proved, the restraint won't be enforced at all. Secondly, the court is extremely reluctant to enforce a restraint of trade that's retrospectively imposed on an employee. And so what tends to happen is an employer will have some sort of scare, something happens. They'll lose a key employee, and that key employee will go to a competitor, and suddenly the employer will be alive to the fact that its employees don't have restraint of trades. So they call the employees in, and they say, look, if you want to continue working for us, you're going to sign this restraint of trade. Now, there are two things to be said about that. The first is nobody can change the material terms of your contract of employment without your permission. It says so in the Labor Relations Act. It's an unfair labor practice. You can't be forced to sign a restraint of trade that you didn't agree to in the beginning. But people often do. People often sign restraints of trade within their employment term. And the reason they do it is that they don't want to rock the boat, or they don't want to lose their job. They're worried about being victimized, and so forth. But if that has happened, the court will look at that as a factor in favor of not enforcing the restraint of trade. So just to pull it all together about when the court will enforce the restraint of trade. The basic issue is that they want to balance the business interests that the employer can legitimately protect. So trade connections, their way of doing business, and so forth, against the interests of the employee. And it takes all of those factors into account. And the courts look at these things with great detail and great care, because they don't like enforcing them, but they also don't like not enforcing contracts. So it's a balancing act. So let me move on to the next question. What do you do if you've got one of these contracts? Well, firstly, I want to just remind you of what I said right at the beginning. Don't sign these things if you can get away with not signing them. Don't put yourself in the position where you have to ask the question of how can I get out of something when you might not have had to get into something. So strike it out, refuse to sign it. Or, and Jan's suggestion was very good, negotiate it at the time. Say, look, 2 years is too much. When I leave you, I'll be quite willing to take 6 months gardening leave, but 2 years is too much. Or stagger it. Say, look, I understand that I've been with you for 5 years, a 1-year restraint is something I'm willing to swallow. But if I've only been with you for 3 months, I'm not willing to endure any restraint at all. We should just walk away from one another. That sort of conversation can be had right at the beginning. But if that conversation isn't had and you have signed the restraint, the first thing to know is you can't go to court to have it set aside. So the court won't entertain a dispute that hasn't become live. So it won't permit you to come to court to strike down a part of an employment contract if it isn't something that where the shoe is really pinching. So you first got to have the employer bring the action against you, which means that you've got to make something of a judgment call. You've got to either ignore it or talk to your ex-employer about it. So on the way out the door, when you talk to the person who currently employs you, you can talk about a number of things. So the first is, in many cases, if you confirm to the employer that you intend acting ethically, you're not going to steal their clients, you're not going to keep their computer, you're not going to steal their staff, which you're permitted to do, but always irritates people. You're not going to make any attempt to take their business away. All you intend doing is establishing your own business in competition to them from scratch. If you can reassure your employer that that's all that you intend doing, many employers are willing to waive the restraint. In particular, if you've given them enough time for them to replace you. So if your clients within your employer can be dealt with effectively by somebody else who's given a bit of a lead in to come and deal with them, then that is something that sets an employer's mind at rest. So the first thing to do is just talk to your employer on the way out and see whether they would not be willing to waive the clause, whether they might not be willing to reduce it. And remember that business competitors aren't in a mortal life and death combat, because often competitors work in a symbiotic relationship. And it's very obvious with estate agents, because often the two of you will have a mandate and the two of you can work it out. Or your competitor has a sole mandate on a property, but you've got the purchaser. So you're not in a life and death combat with them. You actually need to work with them. And relationships need to be maintained and established for after you leave. It doesn't help fighting with your ex-employer, because your ex-employer is the person you're going to be meeting across the table at the next negotiation. But what if that doesn't work? So you've got an employer who has this terrible restraint of trade. You've had the conversation with them. You have no intention of doing anything unlawful, but you think that the restraint of trade is not reasonable. There are two things to do about it. One is to suck it up and just find something else to do during the restraint period. The second is to ignore the restraint of trade. And then let me tell you what happens when you ignore the restraint of trade. And there are, broadly speaking, two possibilities. The first is that the employer will just back down and do nothing about it at all. They will grumble They will have an extra cup of coffee. They'll be rude about you, but they won't do anything. And that happens a lot because it's very expensive going to court. So it's expensive for both of you. But sometimes you find yourself in a position where the employer digs his or her heels in. They say, we're not going to tolerate this. If we tolerate this employee leaving and not abiding by the restraint of trade, then we are going to see a whole bunch of employees leaving who think that they can ignore the restraint of trade. And bad luck for you, we have decided that you are the one that we're going to make an example of. They will then start the machinery of litigation moving forward. They can do it in a number of ways. They will bring in interdicts. They will go to the High Court to interdict you from working for your new employer. And they'll put your new employer on notice. They'll say, there's a restraint of trade here. You can't employ that person. It's contrary to the agreement. We're putting you on notice, and they will then interdict your new employer from doing this. So your new employer gets dragged into the fight as well, against their wishes, against their will, and to their great expense. And there are very few employers who want to have that sort of fight. So they'll bring the interdicts. They will then bring an action against you, because it's not just that you are in breach of the restraint of trade, it's that you're causing them harm. You're stealing their clients. They are losing commission that they would otherwise have had. If Mrs. Smith had stayed with their agency to sell her 12 million rand house, but has now gone to your agency to sell the 12 million rand house, you've lost your 3, 4, 5, 6, 7, whatever percent on that deal, and you've got a money claim. They'll sue you for it, which means that you sell the house, get your commission, and then you lose your commission. If you're in that position, you then have to lawyer up yourself. You've got to retain a lawyer. You are in the High Court, you'll probably have to retain an advocate as well. And very rapidly, the legal costs spiral out of control. These matters can be very expensive. So if your ex-employer pushes it and will not back down, win or lose, you're going to be spending hundreds of thousands of rand, which you can never recover. It becomes a very expensive process. It's one that should be avoided. It's often said that only the lawyers get rich from these matters. It's perfectly true, unfortunately. So it really is a last resort ignoring it. There are very few problems that can't be talked out with the person with whom you have the problem. And so the first and foremost remedy is to talk to your ex-employer and tell them what you intend doing, rather than doing it without warning them, letting them find out later, getting upset, phoning their lawyers, and starting that whole business going. And it's also an ethical thing. It strikes me as important to make the observation that within a business context, it's not eat dog, eat dog. We are meant to compete with one another, but we're meant to do it fairly. So we are not meant, as I said right at the beginning, to disparage our competitors. We're not meant to steal things from them. We're not meant to engage in a practice purely to cause them harm. What we're meant to be doing, all of us, estate agents, lawyers, doctors, greengrocers, is that we're meant to be doing the best we can to be the best we are, to provide the best service for the people who need it, in order that that competitive process can raise the level that causes everybody's levels to go up in terms of service and efficiency for the client. That being so, I think the most important thing to know is that we should be open with our employer and with our competitors. It's a process that starts right at the beginning, with being in a proper conversation with them about how you intend being employed by them, which might, as Johan says, include negotiating a restraint of trade up front. And it threads its way right through to the beginning, to the end, which is that if you know you're bound by a restraint, which you know you agreed to, which you know that you intend ignoring, it would probably be better to talk to your soon-to-be ex-employer to try and find some level on which they can be comfortable with waiving the restraint of trade. That's all I really have to say about restraints of trade. It's a bit of a potted summary of the law, and I say that because I have heard people stand in court and talk about restraints of trade for days on end without getting to the bottom of it. It's for some people a very interesting topic. It's one of those things. My brother-in-law always asks me, do you have any interesting matters at the moment? My answer is always the same, which is that they're fascinating, but only for lawyers, not for anyone else. But it's a very interesting area of the law. Stephen, do you have questions that you'd like me to answer?
I think, first of all, thank you, Adam. That gives us a really good introduction and overview. In fact, some detail on restraints. I think that was very helpful. Thank you. I think I've got a whole list of questions which we can get into discussing. But before I do that, let's hand it over to you, Johan. I know that you have represented clients on matters like this, and you're free to add whatever you feel like will add value to the discussion.
Yes, thank you, Stephen. Yes, Jan and Advocate Brink basically covered everything I had to say. But yeah, just to make it clear, the purpose of a restraint of trade is not to punish the employee. It is there to protect the company's, the employer's interest. So just to go on and say that a restraint of trade is merely a provision in an agreement. There's no codified legal principle. So that is why it's so important what Jan said. The moment you sign on the dotted line, that clause is deemed lawful and enforceable. The onus will be on you as the employee to prove that it is unreasonable. And as Advocate Brink said, no, it will cost you an arm and a leg. It is quite an expensive trip here just to see if the court can rule that a provision was unreasonable. So yeah, I've also seen restraints for duration 3 months plus 24 months. It is important to know that each case has its own merits. So no agent should go out there and say, you know what, it is unenforceable. They will do absolutely nothing about this. It's all about the skills, the knowledge you gained, the experience. You can't compare a candidate property practitioner that has, after 2 months, terminated the agreement compared to someone that has been working for you for 5 years. So the purpose is just to protect that interest. And that is where the onus comes in, that the employee will have to prove that there is no protectable interest, and also that there is no harm in joining another agency should that be the decision at the end of the day to move on to another agency. So the courts will basically look at, they will ask, and what is the employer, does the employer have a protectable interest? Could the employee potentially prejudice the protectable interest? Is it reasonable? And is the restraint against public policy? And that is for the employee to prove at the end of the day. The moment, as Jan said, the moment they signed on the dotted line, the clause becomes enforceable. So, as I said, the best is to negotiate, talk to your prospective employer before you sign, ask if you can rather enter into a non-disclosure instead of the restraint. The restraint, most of the clauses I've seen is valid for, or the duration is up to 24 months. And yeah, the geographical area is quite excessive. But at the end of the day, if you signed, you accepted, and you agreed to the terms contained in the clause. So that is basically an important one. And then it's also just to clarify the protectable interest. That could be something as simple as a database, a list of prospective clients, contact details. So leave the information at the former employer. Don't make contact with clients you were busy dealing with at the time before the date of termination of the agreement. It is property of your former employer. And in terms of AMLers, basically what they say is the employer merely have to allege that there has been breach and prove that the restraint is valid. And you can prove the validity of that merely signing the employment agreement. It was a clause embodied in the agreement and you signed on the dotted lines. So there was mutual agreement and it is what it is. So in order to prove that it was unreasonable, usually you can look at the Basson and Johan case, that is where they, and also the Magna Alloy case, that is where they determine the reasonableness of the restraint. So yeah, they will, as I said, they will look at what is the interest, is there any harm. And another thing to remember is also your prospective employer, that your prospective employer must be made aware of that clause in your previous employment agreement. Disclose the information, not the agreement itself, but just say this is the restraint. I may not operate within this geographical area. Let them do the homework, let them seek legal advice. But before you conclude any agreements, just be ready, because as Advocate Brink said, is they will initiate a legal action from their side. You can't do anything up until that stage. So you'll have to wait for them to proceed, take steps, go to court, and then only is the onus on you to prove that it was unreasonable. Yeah, that is basically it from me. They covered everything. So,
thanks, Johan. Thanks so much. So, I'd like to bring the conversation back to this protectable interest thing, because in my view, and excuse me if this is a jaundiced view, but in reality, what most estate agencies are trying to do with the restraint of trade is not protect the secret herb, and was it the 11 herbs and spices, Adam? That's a nice way to reference the protectable interest, because most estate agents don't have that, estate agencies. In reality, what they are trying to do with the restraint of trade is just stop competition. That's my view. And so if I'm thinking to myself, well, let's be charitable. Do these companies have a genuine protectable interest? If, as the estate agent, I am willing to leave behind the database of clients and commit that I will not work with the clients that were actively being worked with at the time. I will leave the database behind and I do not want the clients. Really, I think the only thing that the company, because you've said it's not training or experience, that's not enforceable. The only thing that the company really can say to me as the agent is, well, you've been working here 3 years and we've helped you build your brand in the area. We've helped you become a publicly recognizable figure. Your face has been made famous because of us. Now, when you put up a new billboard with a new logo, people are going to be drawn to you because we've made you famous. So my question is does that constitute a protectable interest? Because without that, I think most estate agents would be very hard pressed to show that they have done something or given something to this agent, if they're willing to leave the database behind, that constitutes some secret thing that they're not going to be able to do readily somewhere else. So that's my first question. The second one is a small question. You probably just shoot it out immediately, and that's fine. My brother worked in a completely different industry, and he was under a 6-month restraint of trade or 12-month or something. But his previous employer had to pay him for that 6 or 12 months. And I remember my brother, who's a lawyer, he just dismissed my comment about, oh, that's nice that they're paying you for the 6 months. He said, well, they can't. They have to. They're not allowed to leave me without income. They say I can't work as a thing. Legally, they've got to pay me. So they paid him his salary for the next 6 or 12 months while he was on a restraint. Do estate agencies not have the same responsibility to continue to provide an income to the agent during the period of the restraint? That was my second question. So maybe, Adam, we start with you.
Let me take the second question first. No, they don't have a duty to pay you during the period of restraint, but the fact that you are without income and that you haven't been compensated for that, whether it's a take-on bonus or a good salary, that's an important factor. And the employer can enforce these things. I think we've made that point. But your first question was a far more interesting one, and it's what is the protectable interest of an estate agency? And I wonder about it myself. I think the obvious thing is the client base. So you've got your book of buyers and sellers, and as you say, if I agree that I'm not going to take any of those people with me, why would the estate agency suffer any harm? I think that's a very, very good observation. If I'm not taking their book away from them in any way, they don't have any other protectable commercial interest, so why are they restraining me, other than just to prevent me competing and to punish me? And Johan made the important point that restraint of trade is not permitted to be there just to punish people. So the court talks about the impermissibility of using them in terrorem, just to terrorize the employee, because that's what they're used for. So if the court gets the impression that you're just doing this to punish, to terrorize, to disincentivize people from leaving, it will not enforce the clause. And there was also mention of that 30% retention, which is, in my view, a surprisingly common thing in these agreements, that if you leave the firm, you abandon 30% of your income, your unpaid out income. And Jan sent me a judgment of another division where a court went through that clause and said, this is contrary to public policy. And even if it's not contrary to public policy, we've got a thing called the Conventional Penalties Act. And it's a penalty, and a court can reduce a penalty if it's disproportionate to the harm that they're suffering. So I think those 30%ers can be got out of. But Stephen, there was another important fact that you raised. The estate agency will say, so Remax will say to Gerlinde Moser, Gerlinde, we made you. We have put you on billboards. We have put your face in knock and drop flyers. We have put your face on the side of bus shelters. Your face is prominent because of what we have done. There are two aspects to that. The first is that's just a disguised way of saying the training and expertise that you have acquired is from us, and therefore we can prevent you using it again. That's not acceptable. But secondly, there's a thing that lawyers who deal with unlawful competition cases talk about, and it's the concept of leaning on. So if you establish your new business, and your way of doing it is by taking a little bit of glory away from your previous employer. So you're taking their glory, their expertise, their position in the market with you. If you're saying things like, I'm Gerlinde Moser, who used to be at Remax, with the intention of stealing a little bit of Remax's fame, then you will, some lawyers say, you're leaning on your competitor and you can't do it. That is something that the Supreme Court of Appeal has said is not unlawful competition. So to give you another example, if you're a Japanese car maker and you produce a luxury car and you enter our market, and if your salespeople say, look, it's similar to a BMW, what you're doing is you're associating, so the theory goes, is you're using BMW's luster to promote your own brand. And the theory used to be that you can't do that, but the Supreme Court of Appeal has said that leaning on isn't part of our law. And the reason we used not to be able to do things like that, so back in the day, Mercedes sales agents couldn't say that they couldn't say just as good as BMW, is because we used to have the Advertising Standards Authority to which both of them subscribed, but that's gone now. So to answer your question, if what they're saying is that you as an agent are leaning on us to promote your brand, you can do that. If what they're saying is, we put you up on that pedestal so that everybody knew you, and you can't do that, well, they're wrong.
Great. Can I come in quickly, Steve? Yeah, I think this is very interesting and a great question, Steve, about protectable interest. And what I'm getting from this, and I want to go back later and look at Adam's strategy of when you want to leave, tell them you're leaving. But I want to come back to that later. I think that's a fantastic strategy. Everybody thinks, let's ambush them. It's going to help me if I don't tell them. I'm going to be skellum, or I'm going to keep my cards close to my chest. That's how one would think, because you want to be protective, and I understand it. But it's a great strategy to say to them, look, I'm leaving. These are my reasons. I don't want to take anything from you. I just want to go and exercise my trade elsewhere. If you do that, I think you blunten their legal challenge, possibly, because you've told them. You keep relationship because and they respect you because you played open cards. Now that employer will probably deal with you in the future and do deals with you. But if they feel you put the knife in their back, you know how people are. So I think there's a lot of wisdom in that which goes beyond simple legal advice, but it's also good legal advice, because I think if the restraint challenge comes, it'll help if you go to court and say, look, I told them I'm not taking it. It's going to help you. So I think I want to think about that. It's a really very interesting thing we can take away from this meeting, I think. But to come to the protectable interest, what Steve has said, there isn't the 11 secret herbs and spices, and we know who that is. We can say it's that lovely chicken, but it is just the database. So now, of course, if you say, I'm not going to take your database physically, here's the hard drives, here's everything, fair enough, but they could still counter and say, yeah, but you know who the people are. You're in the streets of a little rural town in Limpopo, or even in the streets of Cape Town. You're going to bump into those people, and you know they are the clients of the brand. What are you going to do? Talk to them? You can say, I don't have the database, but you know who they are. So that might be an argument as to why there could be a restraint, because you know who the people are. So then my suggestion is, let's take it further. What if you make an undertaking that firstly, you're not going to take the database, but for 6 months you undertake not to talk with those particular people if you see them. Then surely a restraint can't be enforced, because what's the protectable interest? You've even undertaken not to speak to those people. So I'm just taking it a bit further from what Adam is taking, and that would be my suggestion there. Maybe this is a way we can work to find a strategy for exits for property practitioners to make that undertaking and to relinquish every form of threat to the protectable interest.
Johan, can I just add to that? As a litigation professional, as the person who goes to court, not every client is a dream client. So the worst thing in these sorts of matters is when your client has given the sort of undertaking that Jan talks about. So he said to the employer absolutely nothing about his business interests. So he said to whoever's employing him that he's actually going to go and open a restaurant, whereas in fact he knows that he's off to establish a competitor. Now, nothing necessarily wrong with keeping your cards close to your chest, but misleading your ex-employer is not right. And then the ex-employer brings an application in the High Court for an order to kick your door down. It's called an Anton Pillar application. You get no notice of it, and one day the sheriff arrives at your door with an order permitting him to mirror the hard drive of your devices, your computer, your cell phone, to take copies of all mandates that are in your firm. Those sorts of orders are granted. They are very far-reaching. So if you have said to your ex-employer, I'm not taking the clients, and I'm not going to work for people who are currently on your database, and they kick the door down and they discover that you have retained the database, and you are acting for their clients. And this is in circumstances where you told them you were going to go and open a restaurant. It becomes very difficult to protect your interest as a lawyer because the court is going to be easily convinced that you're dishonest. And if it's convinced that you're dishonest, it won't take the view that, look, this ex-employee has given you an undertaking and you should be satisfied with that because the previous undertaking was breached. So it becomes very difficult when the client does things that fall into the general basket of dodginess, of being misleading about when they're going, about breaching an undertaking, about, frankly, stealing things. So it may seem like a very obvious thing to say, but don't lie to people and don't steal. And, these are basic principles.
Johan, have you got something you want to add to this comment on protectable interest and the conversation we've been having?
Yeah, I just want to say something about that 50 or percentage, 30, 40, 50% administration fee. So, yeah, what I gathered from this is basically they take a chunk of your commission, which has not been paid at the time of termination of the employment agreement. So, that itself basically, should have some questions. Being is, it's not money's due or owed to the agency. It's not a debt. It is not as a result of damages, loss. So what justifies the administration fee? So I'm of the opinion it will be difficult, to prove, how they get to that percentage and, what justifies the amount. I mean, let's say this is a sale of an agreement of sale, immovable property, commission. Now you terminate the agreement and now you get a letter saying we keep X amount as per clause this and that. So at the end of the day, what collection is there? There's nothing to justify the conveyancer undertake to pay X amount upon registration to the agency. And of course, there's already existing agreements between the agent and the agency as to when the monies will be paid upon a receipt from the conveyancer. So I can't see how it can be a collection administration fee that will justify a percentage for them to hold upon a registration or when the commission is payable. So for me also that's I can't see how that will stand. I can then just lastly protectable interest. Maybe it's just worth mentioning, it's not just perhaps it's not just a database. They also restrain you from seeing if you can swing, former employees to join a certain agency. My contact with clients, just to take it further on Jan's topic in this regard, is just when a client can inform the client, I'm no longer employed with this client with this agency. I was a representative of this agency, so I suggest you make contact with the agency themselves, especially if there was written mandates on the record, something that will make it easy for the former employer to prove and say, listen here, we sent you the lead, we've asked you to go view the property with this prospective client, here's everything in writing. So, and then it will become difficult for the employee to prove, because everything is there on the record at the agency. So, and then also, business information methods, it's difficult to determine what is the your trade secret. So it's a business. You can only do that much, and in accordance with to law. So that itself is difficult, as Advocate Brink and Jan said. So it all comes down to being ethical, doing the right thing. Don't store and save existing templates and clientele's information on your devices, because that can be seen as harmful. Regardless of whether you actually disclosed or made use of that information, it is available to you and it is available for distribution, and that itself could be harmful. So yeah, that is it from me. I don't know if there's something else.
I've got one last question I want to ask, and then I'll hand it over to you guys, and you can make whatever closing comments you also would like to add in. And I think this is probably the most important question of them all, built on the basis of the understanding of the law that we've gained today. You know, we're talking about real people and real people's lives, and the first thing they're going to say is, let's get practical. I'm in a certain situation. What do I do now? So let's paint a scenario. I work for an agency. I have gone to my employer. I've been open with them, as you've suggested. I have said to them, I am willing, in fact, to pay you a percentage of the commissions that I will make in the next 6 months. And in fact, I had an agent out in my group who did this. She came from a large franchise. She said to them, look, I'm going to be getting 70% commission at my new firm. I was getting 50% with you. What I'll do for the next 6 months is, if we scrap the restraint of trade, I will pay you 20% of all of the commissions that I do with my new company. And the principal looked at that as a deal and said, okay, I'll take it. And effectively, she was still on a 50-50 split for the next 6 months, so she was no worse off. So she negotiated a way out of it. Now, the point I'm actually wanting to make is this. I've gone to my employer. I've tried to negotiate my way out of it. They say no. I have then offered to make a list of all of current and potential clients that could be linked to the agency, and I'm willing to sign something that says I will not work with these 25 people in the next 6 months. And that was Jan's suggestion. I've offered to do that. They say no. And despite all of my attempts to come to an agreement, I am convinced that other than these things, which I'm willing to bind myself by, this company has no protectable interest. I'm convinced of that there's no 11 herbs and spices here that I'm going to take with me. I don't think the restraint of trade is fair, is legal, is according to public policy, as you've said. Okay, that's the scenario. Here's my question to you. Under what circumstances now would you advise an agent to ignore the restraint and proceed, or to legally take on the matter? Because I don't have endless money, and Adam, you've said to us, well, this thing can get out of control quickly. You know, I come to you and I'm at a braai and I say to you, you know, Adam, Johan, what do I do? I don't have money to have hundreds of thousands of rands worth of court fees. Should I ignore it? Should I go to court and hope that I'll win costs? You know, what do I do? They won't accept my negotiation, but I think there is no protectable interest and it's unfair. What do I do?
Maybe I can start. I think you make your position as good as possible, and you painted a perfect picture of it. As an employee, you've done your best to work out what the protectable interest is, and you've done your best to tell them that that protectable interest is safe in your hands. And you've been honest about it. I mean, let's just assume that. You've then gone a little bit beyond that. You've even offered to pay them a little bit of your commission, which is something to which they're not entitled. It's a sweetener. It takes the sting out of whatever harm they think that they are suffering. But they're being unreasonable. There comes a point where you have to make a choice between abiding by the restraint that you don't think is fair or ignoring. And you can't go to court to get the court's opinion on whether or not the clause is enforceable. The only thing you can do is sit back and wait to see what they will do. But, you know, it's a little bit like a freeway with off-ramps litigation. You ignore it, you go and take employment with another estate agency, and they write you a rude letter, and they tell you to stop. You can pull up the handbrake and say, all right, they're willing to put a bit of money into this to get a lawyer to write me a letter, and that shows they're serious, and I will stop doing what I'm doing. Or you can ignore the letter and say, look, I don't think they'll take the next step. I don't think they'll bring the application. Then they do bring the application. Even at that stage, the costs aren't too great. So it's in tens of thousands, 10,000 perhaps, for drafting the application, for getting the service of it by the sheriff and so forth. You can reanalyze your position. You can say, all right, now they have shown that they're willing to put enough money into bringing the application. Let's look at the application. Let's see how strong the application is. Make a judgment call at that stage. Okay, this is a pretty well put together application. It's obviously been drafted by somebody who knows what he's doing or knows what she is doing. They're making the right sorts of points. They've made some points I hadn't thought of. There's a protectable interest they've mentioned that I hadn't set their mind at rest about, or that I can't set their mind at rest about. And the one that you hadn't thought of, you go back to their lawyers and say, look, we've got the application, but let's talk about it. We hadn't thought of that, but we'll give you an undertaking. Or we can't set your mind at rest with regard to that, but will you not accept some lesser form of restraint? Just because we do accept now that there is something there in that. And if they're not willing to talk to you, you then make another decision about whether or not, in those circumstances, you want what is looking to be quite a big fight, and you pull up the handbrake and say, all right, I agree to an order, but I don't agree to costs. I'm not going to pay your costs. And in circumstances like that, if you've agreed to the order, but you don't agree to pay the costs, that leaves a court in the position where the only thing that they are asked to look at is whether the costs should be ordered, and the courts are always quite reluctant to do that. So my point is that there are many ways to get back out of the position. There are many stages at which you can, just like in poker, decide whether to put more money into the pot or to fold. And just like poker, depending on when you fold, it can be relatively cheap and relatively expensive. Also, by the way, just like poker, going to court is gambling. It is an outrageous gamble. Judges, I don't think I'm letting the cat out of the bag when I say that judges vary in terms of their ability, in terms of their sympathy for the concept of enforcing contracts, in terms of their sympathy for the needs of people to have employment. They vary in terms of their preparedness for the matter. They vary in terms of the extent to which they're willing to listen to certain forms of argument. And it's not possible to predict what judge you're going to get. So in a perfect world, you should be able to say there are 2 or 3 judges in the Cape High Court who are known specialists on unlawful competition. Let's the parties just agree to choose one of those, and then at least we know we'll get a good decision. But that's not how it works. The judges are allocated on a more or less rotation basis, partly because the judge president quite rightly believes that there shouldn't be silos of judges who know only this area of law and only they know that area of law. It should be mixed and matched. So it can be a gamble, but just like with poker, you can fold at various stages and limit your losses.
Wow, that's fantastic. Can I come in, Steve? I think that's very well put by Adam. There's a lot of intricacy to this, but I think we can break it down and we can write up something which is a stepped approach. It's looking like a stepped approach to me. Do this, try this, try this, try this, and there's a way out. But it's going to take a little bit of engagement by the property practitioner in question. So what I get out of this is, yes, start off by approaching the employer and making the undertaking. I'm not going to contact the people. I'm not going to take the database and all of that. And will you release me? If not, then you go to the phase of considering whether you're going to ignore the restraint. Now, for me, the critical factor there will be, is it a good restraint of trade or not? Then it got to the quality of the restraint. So if you're the intern, you've not done any deals, and you don't even have the database, just carry on. That's simple. But as to the quality of the restraint, there I would say go and get the legal opinion. It's not a lot of money for that. Go and get the legal opinion. This is a restraint 8 out of 10. It's a 3 out of 10. You can get an advice on that, good, bad, or ugly, how it is. Then, if it's a weak restraint, my suggestion generally, we take advice, not just from the attorney, get advice from your circle of friends, and maybe you just go for it. If it's a weak restraint, you just go for it. But that you must make your own decision there. If it's a strong restraint, I would say don't go for it just like that, because our courts will uphold it. If it's a strong restraint, then you go the further road of what Adam has said, and you proceed with caution. Just carry on a little bit, you get the letter of demand. Because as Adam has said, in many cases, the employer will just let it go. It's a big hassle for them. Even if it's a strong restraint, they might let it go. There's not the police are not going to come. It has to be your employer getting an attorney, an advocate, and taking it on. They'll send you a letter of demand. You can look at the letter of demand. If it looks a bit weak, you can assess it. You can continue. When the first papers come, then you can decide, is this my off-ramp off the highway of litigation or not? And then you might say, okay, I'll comply, but I don't want to pay the costs. So I think that's quite a very good stepped approach, and I would go with that. I think that's great. And yeah, I just think it's wonderful, and I think thank you for this. I'm going to sign off. I see Adam has to go, and I hope this can empower the property practitioners to make an informed choice going forward.
Thanks, Jan. Johan, anything you wanted to add before we close?
Yeah, lastly, a quick one. It's just as Jan and Advocate Brink said, it is have a look at the wording of that clause. Is it just some sort of general clause that was brought into the employment agreement? How applicable is it to you as the agent? If it's just a general one saying that we will enforce that you may not operate within this geographical area, and for a certain amount of time. And what I'm trying to say is that protectable interest that must be set out. You must know what that protectable interest is. Otherwise, how do you apply? How do you enforce that? So yeah, have your attorney examine that clause, examine the wording, see if it's actually applicable to you, or if it's just some sort of standard general clause that was brought in. It could be that it's not relevant to your situation. So yeah, best is just to seek the legal advice and then take it from there.
Gents, thank you so much for your time. Adam, we appreciate your time this morning. Jan, Johan, thank you again. I think we have produced a resource that will be tremendously valuable to the various audiences that we began speaking about. I'm very grateful for your being willing to participate in the discussion. It's an important one, and I hope that it does help a lot of people in the future. So thank you.